No. Canadian law does not view the Bible as hate speech. Canadians have every right to publicly read, express, and share their views about the Bible, to preach sermons about its passages, as a fundamental right protected by our Constitution. CLF has defended that right for the last 40 years and will continue to do so for every Canadian. That doesn't mean, though, that quoting the Bible will excuse someone from otherwise breaking the law. The Bible is not a get-out-of-jail-free card. So the law does place restrictions on some of the things that we say. We're not allowed to slander or defame people, to issue threats or threaten violence. And if someone simply quotes the Bible to justify some of those types of expressions, that will not necessarily be a defense. But simply reading the Bible itself, or expressing a view about what it means, that itself is not a basis for criminal sanction in our country. In fact, there's a specific protection in the Criminal Code of Canada that protects good faith opinions expressed about religious texts. However, there are some efforts to repeal that protection, and that's why people are talking about the Bible and hate speech right now. It's connected to a study that the government is currently doing around a new law that's being proposed, Bill C-9, the Combating Hate Act. In fact, it was during CLF's efforts to defend that protection before a House of Commons committee that the committee chair asked whether it would apply to someone charged with a hate crime who quoted passages of the Bible that, in the chair's view, were quote-unquote clearly hateful.
I just want to dig in a bit about the concept of good faith, Mr. Ross. In Leviticus, Deuteronomy, Romans, there's other passages, there is clear hatred towards, for example, homosexuals. I don't understand how the concept of good faith could be invoked if someone were literally invoking a passage from, in this case, the Bible, but there are other religious texts that say the same thing, and somehow say that this is good faith. I mean, clearly there are situations in these texts where these statements are hateful. They should not be used to invoke or be a defense, and there should perhaps be discretion for prosecutors to press charges. I just want to understand what your notion of good faith is in this context, where there are clearly passages in religious texts that are clearly hateful.
So I don't know that I would agree with that characterization, Mr. Chair, that passages are categorically hateful, especially not passages in the Bible. And I think if members of Parliament are of the view that passages of the Bible are hateful, that's something that Canadians should be aware of. And I don't know if that's necessarily what you were communicating there. I think your concern is the way that the Bible might be relied upon or cited to advance particular messages. And that was specifically dealt with in Whatcott. And there the court drew a very careful line between speech that we might view as repugnant or offensive or hurtful versus speech that crosses the line into inciting hatred and promoting hatred and exposing a group to hatred, where there's a very different analysis that needs to be employed there.
Now, that description of certain passages of the Bible as clearly hateful has understandably raised concerns, especially coming from a senior government official. But if the chair's point in asking the question was simply that baldly invoking a religious text should not be used as a veneer to protect otherwise hateful expression, then CLF is in agreement, and so is the case law. But the fact that the Bible is not a get-out-of-jail-free card does not mean that it is itself a go-to-jail card. Expressing a view on the Bible is not itself a hateful act. And that is where the lines have started to get a bit blurry, at least in the questions that are being asked about this defense. Any book, any text could be misused in hateful ways. That doesn't mean the text itself is intrinsically hateful. And in fact, the Supreme Court has already pronounced on this question in a case that CLF intervened in called Whatcott. There, the Supreme Court said that people are free to quote the Bible to express very controversial views, so long as they do so in a way that is not conveyed through hate speech. In doing so, the court recognized that people could express diverse views about questions like sexuality without that necessarily constituting hate speech itself. That is why describing passages of the Bible as clearly hateful is really troubling, because it's saying that instead of the misuse being hateful, it could be interpreted as saying that the text itself is hateful, and that, the Supreme Court has made very clear, is not true. I trust this is not what the chair of the committee intended to communicate, and I hope that clarification will be provided in that regard. But either way, if current or future lawmakers do express the view and do start to confuse the misuse of the text with the text itself, it underscores exactly why a defense like this one in the Criminal Code is so importantly needed. And that's a provision that CLF will continue to defend.